Good morning, everyone. I'm Greg McDonald. I'm a resident in our Rochester office and handle a lot of construction matters from, the inception to, dispute resolution. So today we're going to be talking about competitive bidding, particularly with regard to capital projects. And if Kathy, you could move to the first slide. Generally, the central purposes of the competitive bidding statute in New York are the protection of the public monies and by obtaining the best work at the lowest possible price. Also, the prevention of favoritism, fraud, improvidence, corruption in the awarding of public contracts, and essentially ensuring fair and open competition. And the intended beneficiaries of the competitive bidding statutes are the taxpayers, not the bidders. It's intended to protect the taxpayers, and any challenge to an award, and we'll talk a little bit about potential challenges later in the session. The public interest is going to be central, and that's a key consideration as to what a court would be looking at on reviewing any type of protest by an unhappy bidder. And the section, General Municipal Law, Section 103, is applicable to school districts in particular. And with regard to it has discretionary thresholds. So under $20,000 for purchase contracts, there's no need for competitive bidding, sealed competitive bidding. Under 35,000 for construction contracts, and most construction contracts will be over 35,000. So, General Municipal Law 103 is particularly relevant on your capital projects that are, hundreds of thousands and millions of dollars. So it requires the contract to be awarded to the lowest responsive and responsible bidder after the advertisement for sealed bids. And in certain cases, it allows for purchase contracts being awarded on the basis of best value. And with regard to these discretionary thresholds, so they can't be artificially segregated or divided for the purposes of coming under the 20,000 or the 35,000. So that's just one thing to keep in mind. So it's really, and it's generally looked at, especially for contract purchases, on an annualized basis. And the best value awards is for purchase contracts, and it follows the state finance law, Section 163, and it's going to be a responsive and responsible offer also, but different considerations, and it's only applicable to purchase contracts for commodities, certain services, technology. So it's not going to be allowable for a public construction contract, a public works contract. And with regard to school districts and BOCES in particular, to use best value, it's going to have to be by rule, regulation, or resolution adopted at a public meeting. So the Board of Education would have to make that resolution or regulation allowing the board and the district to consider best value. So best value allows, kind of an analysis beyond just the price. So it could have quantitative factors as far as okay. Thanks, Kathy. We can go to the second slide, please. But it can have quantitative factors beyond the price as far as small business enterprises, MWB qualified contractors, or certified MWB contractors, service disabled veteran-owned businesses can be considered. So it provides a competitive analysis beyond just pricing, which allows for consideration of other factors. And with that, I will turn it over to Lindsay for exceptions to General Municipal Law 103.
Okay, I'm not sure if everybody's seeing the slides, but I think we should be on slide 3 now. If you're not seeing them, we'll of course get them to everyone at the end of the presentation. Thank you, Greg, for the introduction to GML 103. My name is Lindsay Crocker. I'm in our Melville office, so I'm sort of on the opposite side of the state as Greg right now. And I've also done a lot of construction related work for our school districts and municipal clients from the inception, including bidding. So I'm going to start talking about the exceptions to GML 103 when you don't have to go out for a bid. So one of them, the first one, or not the first one, but just one of them, is if there's an emergency. So something happens, there's a fire, there's a flood, you know, something breaks down unexpectedly, the boiler, that's when we get often. Obviously, you're not necessarily going to have time to go out for bid. So in those situations, you don't have to wait for competitive bidding and go through the whole process, but the board should still pass a resolution declaring the emergency and authorizing the funding of that project. Another exception is if you're purchasing surplus equipment and you're purchasing that from another government entity or another political subdivision. Oh, thank you. I think I see the slide now. A third one that a lot of our clients rely on from time to time is the sole source exception. That's not set forth in GML 103. It's actually kind of arisen from case law. Out of sort of a need or a practicality that some things are just so specialized that there's only going to be one source. So to use this exception, you need to make sure you only have one possible source and that the products and services that are required are in the public interest. So, okay, what do you have to do that? A lot of our clients I've seen, or from time to time, you know, they'll send me a letter and it will be just the manufacturer or the company saying, yes, we're the sole source. I would go a little further than that. You should do a little bit of background, make sure that they really are the sole source, and make sure you're demonstrating the things you need to demonstrate, which to demonstrate public interest, you have to do a unique, it has to show that there's unique benefits that arise from the particular goods or services as compared to other goods and services. Why can't you use those other goods and services? That there's no other goods and services that provide those benefits, and that the cost is reasonable. And again, recommendation is to always document what you've done to analyze the sole source procurement and then have the board pass a resolution. If we could go on to the next slide. We all know about the exception for professional services. This applies in the construction standpoint to your architect, engineer, surveyors, construction managers. You know, of course, it applies to other people like your insurance agencies and your attorneys. So these are services that utilize professional judgment or discretion. While this is not we had a separate presentation on how to prepare an RFP and protect yourself in awarding RFPs. We won't get into it too much, but just remember that whenever you're doing an RFP, you have to now look at your own policies and regulations. Some districts have specific policies that every 5 years, no matter what, you have to go out for an RFP for a new provider, or there's certain things you have to do an RFP. Sometimes you don't have to do an RFP, you have to do other things. So just always check your local procurement policy. With respect to the request for proposals, again, I think it's always important, especially in the construction context, make sure that your attorneys have reviewed them because you want to get a lot of the legal requirements and things like that in up front so that there's no question when you're negotiating, when you've awarded the contract and you're negotiating it, particularly like the legal requirements, your insurance requirements. And another important thing is to just focus on, make sure it's clear in your proposals document about how the proposals will be judged so that there's no question about transparency or about the way it was awarded in the end of the day. We could move on to the next slide. Okay, piggybacking. This is another one. This came into the law now about 12 years ago. It was added in 2012. You can piggyback or use another entity's contract that they awarded. So you kind of get the benefit of not having to go through the whole bidding process. And the statute sets forth 3 requirements. It has to be let by the United States, a state, or any political subdivision within the states. The contract, and it has to be clear in the bidding documents that the contract must be made available for use by other government agencies. Seems pretty simple, but if that sentence or that requirement's left out, we can't technically piggyback. Those first 2 requirements are obviously the easy ones. It's pretty easy to go through the documents and tell if it has the statement on number 2 and if who it's being let by. The one that's a little bit requires a little bit more effort is the 3rd requirement, which you have to make a determination that it's been let to the lowest responsible bidder or on the basis of best value in a manner consistent with the New York statute. So that the 3rd one, which we'll talk about in more depth, that kind of requires looking at the specific bid documents, looking at the law of the municipality or the locality that is bidding it, because you want to make sure that their laws are consistent with GML 103. Okay, we can move to the next slide. So the factors that, so now the question becomes, how do we determine if it's consistent with GML 103? So the comptroller came out with guidance, and they said, okay, here are some of the things you should look for. It has to be a public solicitation or bid or offer. So make sure there was a public advertisement, that it was advertised in a substantially similar way to how it's done in New York. There has to be submission of sealed bids or offers, or some other procedure that protects the integrity of the process. You have to prepare specifications or similar documents that are similar for everyone. Everyone has to kind of be judged by the same standard, and that the award is ultimately to the lowest responsible bidder, or in the case of best value solicitation, to the responsive and responsible offerer. One thing to remember, I think most of our clients now have adopted the best value standard, but to have done that, you have to have had a policy. So if you haven't adopted that or agreed to use best value, you can't then piggyback on something that used best value. Again, it's important to document this and to document the cost savings justification. The comptroller has commented, and I know in at least one audit that I've seen, maybe more, where they criticize the districts for not documenting the cost benefit analysis and for maintaining the documentation. So I think that's important to do when you're going through this process. And you can remember that when you're going through your cost savings justification, that can include the savings you've incurred, the savings you have due to the fact that you're not now running your own bidding process. Obviously, that adds a lot of administration expense, the cost of advertising, things like that. So you can absolutely include that in your cost benefit analysis. One thing that I just want to note on piggybacking, because I think people get confused about this. Piggybacking is just the procurement method. It's not ultimately the contract. So depending on the circumstances and how it's awarded and the documents involved in the bidding process, in many cases, you want to have another, just like you would when you have your own specifications and your own contract documents, that there's a document at the end of the day that the owner, the school district or the BOCES, and the contractor sign off on. That I still think is very important. You want to make sure that they have the right insurance. You want to make sure you have other legal protections. So just remember that at the end of the day, the piggybacking, just because you decided to piggyback on the bid, that might not be the end of your work in terms of contracting with that entity. Can we move on to the next slide, please? Okay. So this is really like I bet most people on this program probably know these things. This is really going to 101, capital bidding 101, but the preparation of the bid documents, usually in the first instance done by the architect or engineer. Obviously, you have your drawings and your specifications and the things that are specific to what you're building. But then there's a lot of other documents included in the bid documents. That includes the notice of bidder, the instructions to bidder, all the bid proposal forms, which include your certifications like non-collusion and anti-sexual harassment, things like that. So you want to make sure all of that is in, and the most important documents, I think, from our point of view, are the contract documents, which are usually made up of a document which is referred to as the general conditions, and then a shorter agreement that incorporates those conditions as well as all of the other documents. And so I really think that the takeaway at the end of the day is when you're getting these, a lot of times the architects prepare them. Make sure you give them to your attorneys and that they have enough time to review them. They're usually very lengthy. Or in a lot of cases, like we have our own forms for those contracts, so we would just use those. But even the notice of bidders, the instructions to bidders, it's always I think it's always a good idea to have us review those. Okay, next slide, please. Okay, just as a sort of a piggyback on the preparation of bid documents and the specifications, there is a law in New York called Wick's Law. It's in General Municipal Law 101, and it states that if you are if the whole project is going to exceed those costs, which I've listed there, which is if it's over 3 million in New York City, if it's over 1.5 million in Nassau, Suffolk, or Westchester, or over 500,000 in any other county, you have to prepare bid specifications and award the bids for those trades separately. So there's 3 different kind of categories. There's plumbing and gas fitting, steam heating, hot water heating, ventilating, and air conditioning, and then electrical wiring. So it's like plumbing, HVAC, and electrical. This is a kind of controversial law. I think from our school districts and BOCES standpoints, it tends to just add costs and unneeded complexities sometimes. But most, everybody does this. It's been in the law for quite some time. When you don't meet those numbers and it's less, the bidder who can bid on the entire project must include with its bid a separate sealed list of contractors that are then opened. So I just wanted to mention that if you see that in your specifications, that's the reason why. The next slide, please. Okay, advertisement and opening of bids. So again, this is 101. Just know that when you're doing this, it has to be published in the district's official paper or papers. It must be 5 days must elapse between the first publication and the date set for the opening. Usually you give contractors and capital improvement projects longer, but that's the minimum amount. And then they're scheduled to be open. They must be opened and read at the time and place specified in the advertisement, and it must be in public. So I think I'm turning it back to Greg for the next slide.
Thanks, Lindsay. So one of the, I guess, potential downsides of competitive bidding is you can't select who's going to bid on your project. So you're dealing with the bidders you actually get. Your CM or your architect can try to do whatever to generate interest and enthusiasm in your project to encourage bidders. But at the end of the day, you're left with the universe of people who actually bid on your project. So under the competitive bidding statute, the award is made to the lowest price responsible bidder who has complied with the bidding specifications. The documents Lindsay talked about, the instructions to bidders, the bidding documents. So essentially, they're responsive to the bidding specifications. They meet whatever specification, whatever requirements the district has or the owner has, and it's not a conditional bid. Conditional bid could be My bid is $1.5 million if you give me 6 more weeks than your schedule to perform. So they're not responsive to your bidding documents, which require a specific schedule. So a bidder in this regard may be the lowest bid, um, be responsible and still not be awarded because it's not responsive to your requirements. And what you have in your instructions to bidders, so a lot of the documents we see in these contracts are the AIA suite of documents, which is the general the contract and then the general conditions. But there's also instructions to bidders. So in these instructions to bidders, you can the owner can kind of identify what requirements it has for the project, and with regard to that, it's determining what is a responsive bid, beyond responsibility, but just what is responsive. So, for example, you could have that the general trades contractor has to self-perform 25% of the work. That's something we see often, and it's it's designed to avoid general contractors acting as brokers, really just pure construction managers and not holding any of the contract, not doing any of the work themselves. So there's an ability to protect the interest of the owner by requiring specific, and it could be, for example, you have to have been in business 5 years. You have to have performed uh, projects of a similar nature, within the last 5 years. Um, so you have these requirements in your instructions to bidders, and then you get the bids back, and so you're determining with your project team, your owner and your CM and your architect, is the bid responsive? Um, so that's the first thing, and then the second thing is responsibility. So there's an ability of the public owner to waive technical non-compliance with the bidding specifications. One thing we see is the failure to include a certificate of non-collusion, or sometimes a failure to there's typically a bid bond required or bid security of 5% of your bid. Sometimes they forget to include it. So the public owner has the opportunity or the ability to waive a technical non-compliance, something some administrative thing that they failed to do. An owner cannot waive a material compliance with the bidding specifications. And here the owner in the first instance has the discretion to determine whether it thinks that the non-compliance is material or non-material. So the owner in the first instance is going to make that determination, and if it determines it's material, then it just rejects the bid because it's non-responsive. If it determines it's waivable or an immaterial or technical non-compliance, then it has a second determination. It can determine, do we want to waive this, or do we want to strictly have everyone strictly comply with the bidding specifications? So that's the owner's prerogative or discretion. And as far as challenges to this, so whenever the owner's discretion is involved, a challenge is going to be, did the owner abuse its discretion, or is there a rational basis for the owner's action? So those are deferential standards, and the law is pretty clear that strict compliance with the bidding specifications can be required by the owner, and the owner can reject it for a material non-compliance or a technical non-compliance. So that's really gives the owner a first line of defense to to avoid potential issues with contractors that may not be responsive to the bidding specifications. If you could turn to slide 10, please, 11, please, Kathy. So some of the things, is it in the owner's best interest? So again, the best public interest of the owner to waive the defect. And the owner is going to consider whether it gives the bidder a substantial competitive advantage, impacts the integrity of the bidding process, or gives the bidder, the low bidder an unfair advantage. Because obviously, the whole point of this is to ensure fair, open, competition, the protection of the public money. So it's not to give any potential bidder a competitive advantage over another. So that's the determination that the owner is going to make with the project team and its councils, whether it's in the public interest to waive that non-compliance. Again, it's a deferential rational basis standard. But at the end of the day, the owner can, simply stand on its specifications and reject a bid that's not in compliance. And as I indicated, your bidding specifications can be tailored to the responsiveness considerations. Um, and a lot of the times, especially for skilled like masonry work, where it's historic building restoration, you're going to want, and your architect's going to specify that the qualifications of these contractors have to, they have to have done similar projects and things of that nature within the last 5 years. And there's also, you could have requirements for a builder's, a contractor's qualification statement, which has to be submitted with the bid. Their financials, a lot of times you see owners requiring financial statements of the contractor to establish, that's going to go beyond just the responsiveness, but the responsiveness is they have to provide it. Then the analysis is, when you see it, because your qualification statement is going to have things about, have you ever been terminated? Have you been terminated for cause, terminated for convenience? Has your bid been rejected? Have you made claims against the owner? Do you have current litigation against an owner? Have you had bond claims, failure to pay prevailing wage penalties, things of that nature in your contractor qualification? And typically we like to see the AIA contractor qualification statement more robust as far as the details of what has to be disclosed to the owner, because as we indicated, you're stuck with the universe of bidders that you're getting. So you want to be able to get the best bidder, who's going to do it at the lowest price and be able to perform the work within the contract time. If you could go to the next slide, please, Kathy. So once you get beyond the responsiveness, you get to responsibility, and this is a significant issue for contractors in particular, but contractors who do a lot of public work. So obviously, it's awarded to the lowest responsible bidder. It's designed to ensure that the contractor is capable of performing the work within the contract time. You want a contract, so that assessment is a capacity and are they technically qualified to do the work? Are they, an electrician or, a HVAC contractor that, has the capacity and the technical know-how to do the work that they're bidding on? Do they have the financial ability to complete the contract? And, that's where the financial statements come into play, because, a lot of these projects, especially the larger projects, require a lot of upfront advancement of monies by the contractors. And if you look at the contractors' financial statements and they have $50,000 of cash flow or cash in the bank and a line of credit that's maxed out, is that contractor capable of performing a $10 million job that, over multiple years, where they're waiting 30 days to get paid? So those are some considerations. Past performance, especially if the district itself has had performance issues with that contractor, that's in the consideration. Their experience, are they experienced, as I indicated, to perform the work that they're bidding on? Are they reliable? And this again goes to, have they been defaulted, terminated, bond claims? Is there any criminal conduct associated with the failing to pay wages or bid collusion and any of those things? And a lot of the times you'll see on a contractor qualification statement there, it says disclose the lawsuits within the last 5 years. And these lawsuits in New York are public, at least New York State are public. So you could do a search to see, if they disclose no lawsuits in the last 5 years, you can, do a search on the New York State Supreme Court website and see if there have been any lawsuits that they've been involved in. So you're kind of vetting the responsibility of the low bidder before you're awarding it to that bidder. And again, so the issue is not whether another bidder is more qualified or more preferred than the low bidder. Is the low bidder responsive and qualified to perform the work? And if they are, then you're unless you're going to reject all the bids, you're going to award the contract to the lowest responsive and responsible bidder. Next slide, please, Kathy. So you often get, when the issue of responsibility it tends to get the attention of the low bidder, because they're going to, especially contractors that bid on and are perform public work, they're without fail going to have to disclose on their next bidder qualification statement that they've been determined to be non-responsible, which is a big deal. So, the law requires some level of due process, and due process is notice, what am I being determined to be? Why am I being accused of being non-responsible? And an opportunity to be heard to address those concerns. So it could be bidder number one. We understand you have, been failed to complete 4 other projects, have multiple lawsuits against you, and many outstanding judgments. We're setting up a responsibility hearing on this date, and please show up and be able to respond to the concerns. So and that can be as informal as a meeting, with the CM, the owner, and your attorneys and their attorneys, and kind of going over the issues and hearing their side of the story. And then ultimately the recommendation of the board is to, whether the project team thinks they're responsible, and ultimately the board will make that determination. And we've had times where the contractor showed up at the board meeting and to offer additional information to try to allay their concerns or avoid a non-responsible determination. But again, it's one they look to avoid. And a lot of the times you find out when there's a really issue with a responsibility and the owner's not going to back down from the determination, is the contractor will look to withdraw its bid. It doesn't want to have to go through a hearing and a determination, because at the end of the day, they have the burden of establishing that they're responsible. And it's a reviewing court, again, a rational basis standard. So if they challenge it, and they ultimately likely will, if there's a non-responsible determination, they'll do an Article 78 challenging that determination, and the courts are going to have a rational basis standard. So it's important to document and have we've had responsibility hearings. We had a court reporter transcribe or stenographer transcribe that hearing. So you're looking for not being arbitrary and capricious, treating all bidders the same, and then making that determination based upon the best information you have, and then what's in the best interest of the public owner. And I think that the next slide is back to Lindsay.
Okay, so now Greg just talked about awarding the bids, but what if we want to reject all of the bids or reject part of the bids? So it sets forth right in the statute in GML 103 that that a public owner can reject all bids. Even given that, we always put that in the bidding instructions and the notice. You want to make that clear. I think it's also good if you're bidding and there's many different parts to it. You could say we reserve the right to award in part. That way, in case you don't want to award the entire bid, you have that option. When you are going to reject all bids, it can't. You can almost do it for any reason, but it has to be a rational basis. It has to be in the best interests of the public and not arbitrary. So if all the bids came in and they exceeded the amount of money that you appropriated to the projects, or just that you believe now something changed in the short time that the bids were out there and it could result in a lower price, or you looked at your specifications and something could dramatically lower the price. Those are all obviously rational reasons to do it. Maybe you're no longer doing the project. That's another rational reason. Or if just something changes with the project and you need to change the technical specifications themselves. When you do this should be by board resolution. And it should just be clear that you're just not doing it because the person who was the lowest bidder isn't the person you wanted to do it. So we're just going to reject all the bids and bid out the same exact bid specifications. I think now I'm going to turn it back to Greg to talk about some bid mistakes.
Okay. Thanks, Lindsay. So the GML 103 provides an analysis or allows a withdrawal of a bid based upon a unilateral bidder mistake. So it's the bidder's mistake. It's not it's not a bilateral or mutual mistake where both the owner and the bidder were mistaken about the project or the contract in some manner. So this is purely the bidder wants to withdraw its bid. So the statute requires a mistake had to be made known to the owner prior to the award or within 3 days of opening. So whatever that shorter period. So they have to come to you and say, hey, we made a mistake. But and so the bid's got to have been submitted in good faith in the first instance. The error is of such a magnitude that enforcement would be unconscionable. That there's credible evidence that the error was clerical, mathematical, or unintentional omission of substantial quantity of work. So it's not that they overlooked or made a mistake and didn't consider how much it was actually going to cost to do that work. It's more of that they transpose numbers, or that their bid takeoff had 100,000 and they made it $10,000. So a clear mathematical error or a clerical error, a transposition, something that they can look back and show, here are my bid documents, and here's where it made it from my bid takeoff sheets, but it didn't make it to your bid form. And I'm asking to withdraw my bid without penalty. And without penalty means that the owner's doesn't have recourse against that bid bond we talked about to try to recover the cost if they have to rebid, or the next contract is significant, or the next lowest bidder is significantly, the delta is significant. And then the owner has to be essentially be able to be put back in the same position, that they're not going to be harmed by the withdrawal. So those are the principal bases under the municipal law that allow the bidder to withdraw the bid. But I guess practically, if a bidder comes to you and says, hey, I made a mistake, I'm withdrawing the bid, I guess the practical effect of trying to keep them awarding a project that they no longer want probably doesn't make a lot of sense. So in the most instances, there's very few situations that I can recall where a public owner tried to force the issue on a mistake, because generally it's you're setting the project up for failure if you're going to award the contract to a bidder that's looking to withdraw because they made a mistake. Either you're going to they're not going to be able to perform, that there's not going to be enough money to perform, you're going to have to terminate them, make a claim on their performance bond, or they're going to be looking for change orders at every instance, and it's just going to be not a good situation for the project. And there's case law that goes beyond these type of things, that will even allow it, even if it isn't a provable mathematical or clerical error, just based upon the unconscionability factor that a bidder is going to try to establish, that it's good, my mistake, it's $500,000 out of my pocket to finance this project, that I made a mistake because I forgot to include prevailing wages, or something like that's really makes it unconscionable to enforce that. And in the event of the bid mistake is, if they're allowed to withdraw, you can award to the next lowest bidder. And if that's not within the budget, then as Lindsay indicated, you can reject the bid and re-advertise and bid it again. But I think that's the last slide of the presentation. So we're happy to address any questions that anyone may have about any of the topics we discussed today.
There's currently no open questions, but I know this is kind of the area where I think things happen, right? You don't really know what you have a question about until you're in the situation, and then you're calling Greg or me.
I think one of the earlier questions was, are these slides available? We can certainly make them available if anybody, wants a copy of them.
We just got a question that just said, the person was a little late. Do you address the use of cooperative contracts for public works? I'm assuming you mean like a BOCES contract, or I suppose we touched on it in the sense of piggybacking. I know generally for public, Greg, I don't normally see it with big public works projects like just overall, but there's pieces of the public works projects that sometimes come off like a playground or a turf field that can come off cooperative contracts. And what I would say to that is that in addition to some of the points we made, that's obvious. If that could be an exception to the public bidding requirement. And again, when you're awarding it with that, I would just make clear again that I always think it's important to make sure at the end of the day you have a clear what your contract is, the responsibility, the cost, the responsibilities, the obligations, the insurance, and the indemnification obligations.
Yeah, no, I think that's right. And a lot of the times I see, um, part of either the architect or the CM, kind of calling a piggyback a cooperative
Yes.
contracting, where I think the cooperative contracting is more of in the initial, it's a group of, BOCES or, constituents of the BOCES who are, agreeing to cooperate in bidding, certain commodities or, things like that. So,
So she followed up with cooperative such as TIPS or Gordian. I think that those are those entities that I actually had a note about this, and I didn't touch on these specifically when I was speaking about piggybacking. But those cooperative purchasing groups, um, the rules for that are the same as the for purchasing other are the same as the rules for piggybacking. And what I like to say is that when you're doing that, people often ask me, is it okay to use Sourcewell? Is it okay to use this one or that one? And my answer is, I need to see the individual contracts that are being awarded, because it's those cooperatives use awards from all across the country, from all different municipalities. So I don't think, unless they have unless the one that you're dealing with has a specific standard and says all of our bids always do this, 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 and this, I really think you need to look at the specific bid documents and the laws of the municipality that awarded that bid to make a determination under piggybacking.
Yeah, I 100% agree with that. The devil's in the details on those type of contracts. So yeah, you have to make sure, as the Lindsay's presentation indicated, that that they did it consistent with how the general municipal requires, them to have done it, competitive bidding or best value. So yeah, you definitely want to get the underlying documents and the solicitation documents.